And we'll do that on the screen here by means of a PowerPoint presentation. We'll present any maps, photographs of the cases involved today. We'll also present any letters that we've received in support or opposition to a case, as well as any correspondence we've received from other Metro agencies. At the conclusion of our presentation, the applicant will come first to the table, along with any persons in support. The applicant will then present their case to the board. If there's opposition present to a case, the board will hear from those parties opposed. And then after the opposition speaks, the appellant will have a period for rebuttal. The board in their rules provides cases without opposition 10 minutes to present their case. And in contested cases, that is cases with opposition, the board provides 15 minutes for each side to present their testimony. So if there are multiple folks wishing to speak in today's cases, be sure to divide your time up accordingly. That 15 minutes is per side and not per person. All section numbers that are referred to today come directly from the Metropolitan Zoning Code, which was adopted by the Metro Council and became effective January 1st, 1998. I'll introduce and make a part of the record the zoning code, and I'll dispense from reading individual sections unless the applicant or opposition requests that I read those sections. The zoning code requires that these proceedings be taped. Therefore, it's imperative anyone wish to address this board, come forward. Microphone stand looks just like mine in front of me. If you'll hit the button on the right that says speak, your red light will come on the microphone. That mic's active, and when you get done talking, if you'll please turn that off when you get done. It should be noted that it's found anyone presented false or misleading testimony to this board that may have affected this board's decision. Any approval can be revoked at a later date by means of a show cause hearing. The board will go through all cases set for public hearing today, and after each case, the board will then discuss and then vote on that case. The board is vested with the power to act before us as outlined under Section 1740, 180 of the Metro Code of Law. The code requires that 4 members of this 7-member board be present to constitute a quorum. The code also requires that you have 4 affirmative votes to grant your application. We do have a quorum today. We have 4 members present. You need all 4 of these gentlemen's votes to grant your case. In the event you fail to get all 4 votes, your case will automatically be reset for a new public hearing. That hearing date is the first meeting in June, I believe it's 6th. June the 6th is when it would be rescheduled for. No additional fees would be required of you. We'll handle the rescheduling. Applications that, in the event we have a 5th member come and 5 persons participate in the case and you fail to get 4 votes, your case will stay on our agenda for the next 30 days. And then any of those 5 participants can change their vote at the next meeting, or the 6th and 7th member can then review the record and watch today's proceedings and read the file. They can then participate in the next hearing. If you fail to get 4 votes and you have 5 or more members participating, day 31 rolls around, your case is denied by operation of law. The applicant or any aggrieved property owner may request a rehearing of this board within 60 days of today's public hearing. Further, any applicant or aggrieved property owner may appeal this board's decision to Chancery or Circuit Court within that same 60-day period, but once that 60 days has elapsed, the board's decision is final and no further action may be taken. If you're an applicant today and your case is approved, it is necessary for you to come and pick up the permit for which you've applied. It should be noted that you have 2 years from today's date to obtain your permit for this board's approval to remain valid. If you do pick up your permit, barring some condition on the board is placed upon your use, your approval is valid forever. Mr. Chairman, I submit that all cases were filed in proper order. Appellants were mailed by certified mail as required by the zoning code. All affected property owners within 300 feet were notified by first-class mail, and the legal ad was published in the Tennessean. Before we begin, I do have a couple preliminary announcements.
Joey, I had a question for our counsel. I don't know if he's had a chance to find the answer. You're good. We're good? Okay, never mind.
Okay. The preliminary announcements, the first being case 45 at the bottom of page 2. That was the last case on our agenda. That case has been deferred by the applicant until July the 18th, 2013. It also came to my attention that this applicant had not held their neighborhood meeting yet either, so it was deferred anyway. But they went ahead and chose the date of the 18th for that deferral. So that case will not be heard today. And that's all the preliminary announcements I have. Members, do you have anything to add? Okay. Looking across our vastly populated room here, I do not see any elected officials present, so we'll dispense from that. The board does have a consent agenda, and prior to today's case, a board member reviews the record in each case and prior to this hearing, and if in their opinion the applicant meets the criteria for the application they've requested, and they feel that testimony in the case would not alter the material facts, they recommend the case to the remainder of the board for approval. I'll now enter into the record all those cases recommended by Chairman Whitson for approval. And if you're here in opposition to any of the case numbers that I call, please raise your hand and we'll hear it in its regular order. The first case recommended for consent today is at the top of page 2, case 2013-43, Manuel Paradis, the owner at 146 Harris Street, requesting variance and side setback to allow the construction of a two-story addition. Is there anyone here in opposition to case 43? Mr. Chairman, seeing none, this case comes back to you on a time limit restriction. This board approved it in 2010. Mr. Paradis was unable to complete the work and is seeking reapproval. For that, it's identical in all other respects. And the second case and final case recommended for the consent agenda is case 2013-44, Ms. Sharon Piggott, the owner of the property at 3713 Woodmont Boulevard, requesting an item D, which is an addition to a non-conforming structure in R20 to construct a 425 square foot living space and an attached garage addition to the front of the residence. Is there anyone here in opposition to case 44 present? Mr. Chairman, seeing none, there is no increase in the degree of nonconformity. The applicant's request actually is further away from the property line than the existing structure. The existing structure is approximately 3 feet from the property line. This addition would be further away. It does conform to the setbacks on the street, so the front setbacks are not an issue. And with that, you've recommended this case for the consent agenda. Those are the two cases we have today.
Okay, so we have a motion. Do we have a second?
Second.
Got a motion, got a second. All in favor? Aye. Any opposed? Passes.
Okay, if you're here for cases 43 and 44, you have been approved. Again, follow up with the Codes Department beginning on Monday, and we'll help you finish up the permitting process. And with that, you're free to go. You're also free to stay with us. And as we call the first case, case 2013-42, Mr. Mark Farr is the appellant. Clinton Doss, the owner of the property at 700B Fatherland Street. Is the applicant present? All right, come forward, please. The opposition present? Any opposition present? Okay. Seeing none, you'll have 10 minutes to present your testimony. If you'll give me just a moment, I'll put together, show them the photographs and such we've taken of the property. This request comes to you guys, and it should be noted I've also received a letter in support from Councilman Westerholm, a copy of which hopefully you have with you, an email I'd received while I was out. Mr. Farr is requesting a change in the nonconforming use in the R8 district. This is also in the Historic Preservation District in UZO, to rehab and use 1,625 square foot portion of this non-conforming non-residence building and use as a furniture store. Under the zoning code, furniture store is a distinct classification. In case there's a question, why is this not retail? There's actually a distinct category for furniture stores. So the council, in its adoption in '98, separated that use from retail. This is referred to the board under section 1740-660 of the code. The appellant has alleged jurisdiction under section 1740-180 item D. I'm going to step over here and show you the photographs.
Excuse me, George.
Yes, sir.
That gentleman just came in.
He was in here prior.
So he's not in opposition?
No, sir. Sir, you have any opposition case 42?
Okay.
Okay. The subject property you see here is the R8 parcel. It's bound in the red line. It's at the southeast corner of South 7th Street and Fatherland Street, again over in East Nashville. This is an aerial photograph of the subject property. As you can tell, that this structure, when I say non-conforming, non-residence building, this building clearly was constructed to not be a residence, as you'll see in the photographs here. It exists and predates the zoning for this area here. By doing so, it does maintain its protections under 137208 of the state code. Our code also vests this board in the power to hear changes of use in non-conforming zoning situation. So if this were zone CS, it wouldn't be here, but since it is zone residentially, this board is empowered to hear the cases on it. Didn't mean to skip through the site plan. This use, based upon the size, has not required any parking. It is in the UZO. Based on the square footage of this tenant space, there's no parking required. This is looking at the tenant space in question, and I'm standing on Fatherland Street facing south looking at it. Adjoining properties to the left and toward the intersection there at South 7th and following. This is South 7th. There's currently a restaurant tenant in the corner building here, and I believe formerly, I don't know if it's still there, a barbershop that was also located in the back portion. This is behind the restaurant at the corner.
And Joey, could we have our counsel remind us, this is item D, correct? Appeal?
It's item D. It comes to you, and of course, item D refers to the section under 1740-180 as to what you get to hear. And then the section, as noted in the actual docket for today, is 1740-660, is where you get into the business about non-conforming structures. Board of Zoning Appeals typically reviews to see if, in fact, this is an expansion of the degree of nonconformity in cases like these. And I know I'm basically mirroring everything Joey's already told you, but it's the fact that it is in an R8 or residentially zoned area that puts it in front of BZA, despite the state law protections afforded under the grandfathering statute.
And so the standard is the degree of nonconformity increasing or not relative to what it is currently being used for.
I'll just read from the section of the code that applies. It's 1740-660, nonconforming structures, subsection C, enlargements or conversions. At least I believe this is where we're headed. A nonconforming structure may be enlarged or converted to another permitted use, provided there is no increase in the degree of nonconformity. Nice, concise statement.
Thank you.
Mr. Chairman, I believe you do have in the record reflect we did receive letters in opposition.
I believe we received 3.
Yes.
Okay.
3 in total.
Okay. Thank you. Okay. Would you like to proceed? And if you could introduce yourself first.
Yes, my name is Mark Farr, and this is my wife Karen and my daughter Erica. Their ideas are going to be opening up a furniture store. Found this building, a very unique building in the area that we was wanting to do something like this in. Think it'll bring some pretty good traffic with a good outstanding restaurant next door. The barber owned the building. It was a complete commercial building at one time, and he changed it over to residence so he could get some income. The resident consists of that storefront right there is blocked off. Where you look inside, it's just brick wall, and then it's got some mattresses on the floor and a hot tub in there and a lot of electronics. Younger kids living in there. And our idea is just to gut it, and stain the floor, and put some pretty cool furniture in there to sell.
Okay. Well, I think all 3 letters in opposition, well, I guess one didn't articulate a reason, but the other 2 articulated traffic in the area. Have you got a plan for traffic? And I think one was specifically aimed at not blocking a shared driveway.
Well, I guess after talking with Joey about the parking, it was zoned for 2 parking spaces, and we'll be parking in the back, fenced-in area. As far as the main parking, I wouldn't think it would be a high traffic usage.
Have you talked to this neighbor that has concerns about blocking the driveway?
Not personally, sir. We did go to the committee meeting with all the residents. There was probably 30 or better residents present. Peter Westerholm, the councilman, was there presenting what we was trying to do and wanting to do, and seemed to get approval from them at the meeting. Didn't have any oppositions come up to us at that meeting.
So,
30 present or so.
for example, you're in the furniture business. You have shipments and people that buy things. You take furniture out and put it on a truck. And so where does all that happen? How's all that work?
Well, it would be in that loading zone in the very back in the fenced-in area. It wouldn't be like through the front of the building, through the sidewalk. There's a real nice loading zone right there in the back.
Is there enough room for the trucks to pull up and be out of that drive?
Oh, yes, sir. It'd be out of the drive and out of the sidewalk.
Have you seen this letter of opposition?
No, sir, I have not.
Well, I think it's a letter of concern. I mean, it very specifically says, although we support Mr. Farr's request to use the property as a furniture store, is contingent upon our concerns of traffic. So, I mean, they're not saying they don't want it, but they're asking you to have a plan for accommodating blocking the driveway. So, I mean,
Yep.
Okay.
It does not seem that the rear parking deck, and you could correct me if I'm wrong, would accommodate an 18-wheeler. It's just like one of these smaller box trucks.
Yeah. And could y'all speak on it? Yeah.
Come on up and introduce yourself for the record.
Sorry.
My name is Erica Judd. I'm going to be one of the ones working at the store. And by furniture, I guess we mean more of like a refinished furniture, kind of like a boutique. It'll be things that we're bringing in ourselves. It's not going to be like a Havertys or something where we have shipments come in. It's going to be things we bring in ourselves.
Like you said, consignment?
Yes.
But
kind
no
of like,
big trucks will bring in
No, sir.
anything?
It's more of a furniture boutique that we are bringing in ourselves. So.
And you won't be manufacturing or anything there?
No, sir.
So, for example, I mean, what type of furniture? Are we talking chest of drawers? Are we talking beds? I mean, how big are we talking when you talk about furniture? Couches?
No, my name is Karen Farr. It'll be like dressers, things with mirrors, little coffee tables, things like that we find that we refinish ourselves. And, so, of course, there'll be market items, little small home goods also.
You said something about a residence. Is that was originally at one point like 3 different businesses in there or something, a barber shop, and I know there was like a wine shop or something on the corner at one point.
Currently, there's a residence, a restaurant, and the smaller end piece is a barber shop.
So which, you talking about the entire building doing this in there, or just
No,
portion?
just the one
that
section.
piece.
Excuse me?
Just the one
That
section there.
section right there
Yes.
with cursors on.
Oh, okay. The restaurant remains, correct?
Yes.
Okay. And I'd gotten an email, and I don't know if it was one of these letters or a separate email. Somebody was concerned about the parking because there's a restaurant there, and they were worried about the overload of parking based on the addition of another business there. So I assume can you clear me up? Was that the same? Okay.
Yes.
So, Joy, what are the parking requirements for a furniture store?
Furniture store, there in the UZO, the first 1,000 square feet is exempt, and then it's 1 per 1,000 for the remainder. This one, once we look at the floor plans and figuring out the square footage, you essentially end up with no parking required for this use. The restaurant tenant and the barbershop has no parking required under the zoning code. The restaurant space, I have not been inside there. To pass, if there are fewer than 20 seats, there would be no parking required at all. As a takeout restaurant, as a full-service restaurant, the first 1,000 is exempt, and it's 1 per 150 for its space. All of the uses here currently, if the code does not exempt them from parking, they would be legally non-conforming as to parking on the lot. The discussion about this space that these folks are wanting to occupy being a residence, that we had no permits on file for any residential use out here. So if that occurred, it wasn't a legal change of use on that space.
So what are we basing the amount of nonconformity on? Is what it should be used for, or what it is used for? And it's just that space, or is it?
The actual, and the reason I differentiated at the beginning retail, the last tenant that we had in that space was a retail use that we had permits on in our office.
How long ago was that?
It's been probably greater than 25 years ago. So that's for us, if furniture store were still like I say COMZO, the prior zoning ordinance, we would have actually issued the permit since it wasn't a change of use. But furniture store is actually a different category now.
So, and I guess I'm asking this to
Well, I guess
our freshly minted bearded councilperson or counselor, that as far as parking goes, the standard would be that the commercial retail use and whatever its parking requirements were. I guess what I'm getting to, since there's no parking required, it would be hard for me to understand how it could be more non-conforming in terms of parking. Am I correct in that assumption?
I'm confident that I don't understand.
If there was any parking requirement before and there's no requirement now for parking, then in that sense it conforms no more or less than it did before.
It would appear, just as the way you laid it out, it would appear that there is not a situation here where it is more non-conforming with regard to the specific issue of parking. Certainly, the parking requirements seem to have gone down under that analysis. Sorry, I misunderstood first.
I don't know how you could have misunderstood that plainly worded question. Thank you.
Question, what the restaurant that's just there now, is that a non-conforming use as well?
yes, sir. Any commercial operations on this property would be non-conforming. For purposes of what the code says, retail now the first 2,000 is exempt from any parking. Then it's 1 per 200 for the remainder. Furniture store, the first 1,000 is exempt, 1 per 1,000. And then
That's higher than it used to be, Joey?
yeah, actually, well, because furniture store was retail. We didn't have a separate classification under the prior code. They broke those out, I think, principally for like she described, the Havertys and the larger chain stores where those big furniture dealers weren't being hit with a 1 per 200 ratio like retail was. I think that was the council's basis for splitting them out.
So the council recently split it out?
In 98, with the adoption of this code, they separated the two.
So actually, there are required one parking space because it's 1625, right? So for that 625, does that not?
Well, that part
or does
of
it have to reach 1,000?
Yeah, part of that space too is going to be inventory stock areas, which don't come into parking.
Oh, okay.
I give you the 1625 as a gross. There'll be portions of that space that aren't
And
display space.
you folks aren't using the brick garage that's on the property. That's not part of your space, or it is?
It is part of the space, but it is not part of what the store.
So how big is the retail space? And if you said that already, I'm sorry, but I only see the 1625, which is gross. So
I would say it's probably going to be about half of that space, actually.
less than 1,000.
It's half of 1635.
Okay.
And then the little barn is 310.
So your public portion of this is 800 or 900 square feet?
Yes, sir.
Okay.
We do. The inventory stock areas of these we separate out since they're actually zoning code actually lists an inventory stock area of 1 per 1,000 for it too. So we do separate those classifications.
I don't think I'm concerned by parking, and so we've got two generalized oppositions based on parking, but that doesn't seem to be a concern. But the third opposition letter, which I had delivered to you, does, I think, ask a very valid point, which is you can do this without blocking their driveway and would work to not block their driveway. Okay. I just wanted to get that. I just wanted to get that on the record.
Is there concern also that others might be blocking the driveway with the increased traffic? And I think that's what part of their concerns are too.
Yes, I think that is, but to me, that's an enforcement issue. I mean, you can't park in front of somebody's driveway, and so they can call the police. But as long as these people, in my mind, agree not to block it with their deliveries.
And certainly you guys are allowed to condition their approval upon such a thing as well.
Do you all own the property?
Closing tomorrow.
Okay, so but your intent is to buy that, and you'll buy the whole building, is that?
That's correct.
Okay.
You're half of the building,
The complete building.
including the restaurant?
That is correct.
Oh, okay.
All right, I'm just curious. Did you say that the residential part just has mattresses and electronics? I mean, this has nothing to do with my analysis. I'm just.
It's a really cool business, and it's in a really cool part of town, and and I guess the barber who is owned the building from his parents from way back, it went vacant. The commercial side went vacant. He got it turned into residential so he could get some income. And it is a younger style apartment, I guess you would call.
It's a bachelor.
Bachelor pad, I guess you would want to call it
East
that.
Nashville flat, come on.
Exactly.
I'm sorry, I'm 51. These things are kind of foreign to me.
It shocked me too. I'm 50 myself.
Fair enough. Any other questions? I would move we close the public hearing and enter discussion.
I'm familiar with the area, and I don't see an increase in the nonconformity. Actually, a restaurant requires more seating for area than their use would require, so I could support it.
I agree, and given the kind of use of this isn't, it's kind of fixing up older and smaller furniture. I just don't think there are going to be a lot of kind of extra truck traffic for delivery, one, and the traffic, it'll be someone coming in and they might load it up into their car pretty quickly, and I just don't see there are so many other businesses, if you could have that space, that would be a worse impact than this kind of consignment fix-up furniture store.
Okay, having heard all of that, I would move that the board approve the proposed change to the non-conforming use of a building designed and constructed for non-residential activities, as the board finds that the new non-conforming use is no more non-compatible with the surrounding land uses than the existing non-conforming use.
I'll second.
And I would like to add an amendment that no blocking of that driveway.
Thank you. I
Stipulation.
I appreciate that. So we've got a motion, we've got a second. All in favor? Aye. Any opposed? Passes.
Thank you.
Okay, with that, the Board of Zoning Appeals is adjourned today. Thank you.